Hello, everybody. Hello, Auntie M. Hello, Sir Philip. Oh, look who just heard. Yep. She's like, oh, Mama's going live. It's my time to shine. Hello, Rocky Lennon. Nana Laura, how you doing, sweetie? Oh, you didn't hold up the start, sweetie. I just really wanted to say hello to you. I love you. I'm glad you're here. And don't worry, I do it all the time. Oh, hello, Shane. You get a big old yawn from Eva. Ginny, great to see you. Now, what do you think that is, anyways? It's I love you in sign language. It is that time. Hello, Joey Bag and Donuts. Hi, Karen. Great to have you here tonight. Oh, Linda Applegate, thank you so much. I hope you sleep sweet. Hey, Sheena Lee, welcome back. I hope everything's okay for you. Okay, I'll go get the treats. We all know what she's waiting for. Who am I fooling? Do I want to really pretend that it's me? All right, baby girl. Get out your 3 biscuits. That's more than 3. Wait. There we go. Oh, one's kind of broken, so I'll give you get like 3 1/4, maybe. Oh, we're going to have some fun today. I love Judge Oakley. He is awesome. He's always been one of my favorites. He's just direct and to the point and funny. And he's no nonsense. Which one do you want? Do. Oh, I'm really sorry you're having that trouble. I don't know what to tell you. I know I've got full bars, so I don't think it's coming from my end. I'm sorry. If you get behind, just speed it up a little and catch back up. I've had to do that before. What's up, girl? I'm gonna have to give you one of your Grandma Bonnie bones. Jody Gardner, my love. How you doing, honey? So yeah, tonight we're gonna see, is it 3 or 4 cases? I think it's 4 cases in Judge Oakley's room, and it's from today. He's so funny, and yeah, he spits facts. He tells it like it is. Oh, I know. You don't know how badly I want to sometimes enhance that. But honestly, like his streams go for like 5-6 hours. So it's, and I gotta, as I edit it, I gotta watch the whole thing. So it takes a long time, and listening to the gossipy stuff, you know, might take a little longer. Oh my gosh, Joey, you're awesome. Thank you so much. I know those are really for Ava, but I appreciate them. Isn't he amazing? Yes. Thank you so much. You make my chat people so happy. All right, guys, let's get right into it. I just got to find where I put it. I'm sorry. There we go. All right, guys, let's have some fun.
Mr. Williams. Are you Williams? Good morning, Mr. Bowditch. Your appearance for Mr. Williams.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Williams. Your Honor, today's the date and time set for a show cause and arraignment in this matter. We waive formal reading and stand mute. We've also had a chance to pre-try this case. We do have an executed plea agreement subject to court approval, along with a little explanation. But Mr. Williams would be pleading guilty to a fishing violation, with the understanding the matter would be taken under deferred sentence for a period of 90 days. If he complies with all the court's wishes, the court hopefully will consider dismissal of these charges.
All right, Mr. Williams, do you understand your rights and options?
Yes, sir.
You understand the possible penalty for the charge?
Yes, sir.
Understanding all of that, are you pleading guilty to the charge freely and voluntarily?
Yes, sir.
Did you, on May 24, 2024, take some fish out of Belleville Lake at the Belleville East launch? What I've got a notation is 2 smallmouth, 1 largemouth out of season, correct?
Yes, sir.
Satisfied? Satisfied, Your Honor.
Anything I should consider before I sentence?
Your Honor, the season started the next day.
But it didn't start the day before.
Nope, but I consider that the fish's fault. But
Well,
here he is.
That's because you're from the South.
He's just minding his own business. And this fish just jumped on his hook and got him in trouble.
See, I've read these statutes, Mr. Williams, and suicidal fish are no exception.
Yes, sir.
Anything else?
He will sin no more.
All right. So court costs are assessed the amount of $145. I'm assessing 3 restitution fees to the DNR of $20 each. So that's $60 in restitution, $145 in court costs for a total of $205. Can you pay that today, or do you need some time?
I need some time.
Go downstairs and work out your options.
I get part of it.
Go on downstairs. We got options.
Okay.
All right. Stay out of trouble.
Thank you, sir.
Are we ready on the Peterson matter, folks?
Morning, Judge. Can you hear me okay?
I can.
Defense is ready.
People are ready, Your Honor.
All right. If you two put your names on the record for me, we'll get started.
Good morning, Your Honor. Sarah Bonoma on behalf of the people, P841189.
And good morning, Judge, to you and your staff, Robert Burton Harris, P81843, on behalf of Mr. Chris Peterson, who's present, zooming in from the Wayne County Jail, since this hearing being conducted on.
Thank you. And Mr. Peterson, can you hear everyone all right?
Not really. Just give me.
Not really? You want us louder?
A little louder.
All right, we'll try that. All right, counsel, I understand we've got 2 items up today, both from you. One is order of indigency, and the other is a bond reduction, correct?
Sorry about that, Judge. I was getting a call in. Yes, that's correct. It's two issues.
All right, well, let's take the
Want me to address
indigency
that now?
first, just because that happens to be on the top of my file. People have any position? I'm assuming you've seen the documentation, counsel?
Yes, Your Honor. I don't have any further information besides what he put in the motion, so I would have no position.
All right. So what you didn't tell me is any information so I could make a determination the guy's broke.
Well, I did include where he works, and I looked at my notes, and how much he makes per hour just escaped me, so that's why I didn't include it in my motion. I did indicate that, because Mr. Peterson is present, if you had any questions about how much money he actually had access to or made, he certainly can answer those questions for you directly. I don't believe that he makes more than $23 an hour, and I know that he was working part-time. So to the extent that he's able, he just can't afford investigators and experts in this case.
Okay. All right, Mr. Peterson, where do you work, sir?
Guardian Angel Care, which is my mother's
Yep.
company. That's a home health aid, helping elderly people.
I am, Your Honor, and I apologize. I'm having a lot of.
Mr. Bickert, I'm in the middle of something else right now. I'm sorry, Mr. Peterson. Why do you work part-time?
Said I also work
Why
with
are
my
you
father.
working part-time?
Because I also work with my father. He owns a lawn service company.
So you have two part-time jobs.
Yes, sir.
Okay, and how much are you paid hourly on both jobs?
With Guardian Angel Care, I get paid 15 an hour. And the lawn service I don't get paid hourly. I just get paid at the end of the day. Actually, I get paid 15 an hour from that too.
All right, and how many hours a week do you work between the two jobs?
I'm not
Are you
too sure.
averaging 40 hours a week, 50 hours a week? How much are you working?
Probably like 20.
Then go get a third job.
Yeah, about time.
How old are you?
24.
Are you healthy?
Say it again.
Are you healthy?
Healthy? Yes.
Then you should be working 70-hour weeks.
Can I add something for the court's indulgence, Judge?
Not unless you got a job for him.
Well, what I was going to say is that what Mr. Peterson is not including is sides with his younger sisters and a cousin, who he also helps out with on a daily basis. So it's not that he's just kind of sitting around not doing anything. It's just that he has other obligations as well.
He ain't working as hard as he should be, I can tell you that. I'll sign the order. Let's talk about the bond.
Appreciate that, Judge. So I think it's pretty clear from the motion. I kind of laid everything out. He's 24 years old, no criminal history whatsoever, never been in jail, never been in custody. This case is a prima facie case of self-defense to the extent that, that will be the defense. Frankly, Judge, I don't even know, and this is something I'm researching, I don't know to what extent the prosecutor is going to be even able to argue that the decedent in this case was not violent. And so the likelihood of conviction on this charge is extremely low, to say the least. As I put in my motion, he, like I said, has never been in jail. The Wayne County Jail is not staffed and not appropriately staffed, I should say, to be able to protect him long term. And so the magistrate who arraigned him, after I explained the circumstances of this case, felt that because initially his gut reaction was to just remand him because of the charge. After I explained the details of the case, he changed that so much that he didn't even order a tether for Mr. Peterson, but he still kept the bond at a $250,000 cash amount, which was just completely unaffordable. Mr. Peterson is obviously not he's in jail. He doesn't make a lot of money to the extent that his family could afford to retain me. They don't have the money to pay a $250,000 bond. And so, Judge, I'm asking for a personal bond because there's really just no reason not to give him one. I think the best indicator of future behavior is past behavior. And this case, officers arrived. Mr. Peterson was sitting on the end of his driveway with a gun next to him that was made safe with his CPL and license on top of the gun. So he's clearly indicated that he's in no way, shape, or form a flight risk, and he's certainly no danger to the community based on what I said. Sister Council has sent me most of the discovery, I think, on their end so far. And so this was captured on video. You can see that what's on video supports what he told the officers to the extent that those statements are going to be admissible. So there's just really no reason to have him in jail other than the specific charge. But obviously that is not the only factor when you consider bond.
Thank you, counsel. Response from the people.
Your Honor, just to start, so just briefly touching on the facts, we have ring camera of the victim parking across the street from his girlfriend's house or his ex-girlfriend's house, a couple houses down. We have the defendant, which is the defendant's mother. That's her boyfriend or ex-boyfriend, I'm not sure. We have the defendant who's trying to ask his mother, is that the victim? Is that the victim out there? But he can't get a hold of her, she's in the shower. That's when the defendant and his cousin calmly, casually walk across the street, armed with a gun. The victim exits his vehicle, goes to the passenger side to approach them because they have already approached him. There's some kind of conversation that took place, and then the defendant shot at least 7 times, if not more. There's no gun recovered off the deceased. The defendant doesn't say he had a gun when the police come. The cousin doesn't say he had a gun when the police come. They casually and calmly walk back across the street, all on ring camera, as the mother is hysterical. She's screaming, "Why would you do this?" He pulls up a lawn chair and he sits and waits for the police to come. I want to talk about the motion that defendant submit to the court. It says the shooting occurred at his home. No, it didn't. He was in the safety of his own home. He chose to leave the safety of his home and to confront the victim. He decided that in that moment, he's going to be judge, jury, and executioner. And then in the motion, it says the deceased has been abusing, stalking, threatening, harassing Mr. Peterson's mother, himself, and his family for years prior to the shooting. That's not self-defense then. He knows what he's doing. He went over to confront the deceased and he had a gun. He knew exactly what he was doing.
And be that as it may, we have to remember that the purpose of bond is, if they're a danger to themselves or a danger to others, is to protect the community. He definitely is showing that he was a risk to that one person, but does that put anybody else in danger? It's a reasonable question. And as far as so they can stay at your place, that's 100%. Yeah, I agree with that comment. But unfortunately, the courts have a very, very narrow window of the things that they can look at when setting bond.
The shortage of the Wayne County Jail is not permission for someone to get a personal bond. The fact that he's not familiar with jail, that's what the defendant's saying. I'm not familiar with jail and violent offenders, so I shouldn't have to sit in prison. He's the violent offender. The argument maybe can be made for someone on a CCW or a little possession charge. This is a homicide second degree. I think $250,000 bond is way too low for a homicide. I am asking for a remand of the bond, and I'm asking for an exam. And after the exam, after the court has the opportunity to review the evidence, then we can address bond, Your Honor.
All right,
May I have a last word?
Mr. Burton Harris, anything else?
Yeah, so for a couple things. The defendant's statements support everything that's on the video, and I don't think the sister counsel said otherwise. I'm not sure how she said that.
Hold on. I lost your audio.
Can you hear me okay now?
Back way up. Back way up. You blanked out.
Okay, so I was just saying that I just want to address a couple things sister counsel said, and didn't say. The video supports exactly what he told the officers. I don't know how sister counsel knows what was said, because she's correct. The ring camera is from across the street, so you can't hear the conversation, but you see the my client backing up. You see the decedent coming at him and his 16-year-old cousin who was standing right there. So she's correct that it was across the street. And if I put it in my motion that it was at his house, that was just inartful on my part. But the shooting did occur across the street. So that's one thing. In terms of the reasons for confinement, Sister Counsel has flat out asked you to do something that's unconstitutional in the sense that she wants a high cash bond expressly so he can't get out. It's not connected to dangerousness. It's not connected to any type of flight risk whatsoever. In terms of what the mother said, I'm not exactly sure why that's relevant at all. I cited in my motion multiple police reports, multiple criminal court cases that were prosecuted by this prosecutor's office for the decedent. So the question about his dangerousness and whether or not my client has the right to go and speak to somebody because he has a CPL and carry a gun, I think Your Honor knows that is his protected right and that he can do that. The fact that the prosecutor has acknowledged and doesn't dispute this prior threat, stalking, et cetera, it honestly just kind of baffles me because the idea that my client has to stay in his house when there is a threat that has been ongoing and outside is not consistent with the law. And so if Your Honor is inclined to do some cash bond, his family cannot afford to pay more than $4,000. So I would ask that you would make a $40,000 cash and surety bond with a 10% provision so that they can post it. He can face these charges. He's already demonstrated he's not a flight risk. And in terms of him being in danger, I think we've already addressed that. And Sister Counsel hasn't said anything to dispute the circumstances of this shooting.
And Your Honor, if I can briefly.
Sure.
I guess the first thing is I'm not agreeing that there's been abusing and stalking and threatening. That's the defendant saying that. So how are you going to come back and say now it's self-defense if this has been going on? He knows what he's doing. He's also asking to drag the deceased through the mud about his criminal history, his past. And he's citing a 2005.
Counsel, let me stop you. I have to agree with defense counsel. I don't think you understand the purpose for which I set bond. You want to try the case today. Tell me why this individual is a danger to himself or others. Tell me why there's a danger that he won't show up. That's what I'm supposed to be determining today.
Okay. Well, I
I'm
can't
not trying the frickin' case.
I understand, but I can't say that he's not going to show up because he doesn't have a criminal history. So I understand that. But he's charged with homicide second degree. And we can't just
I read the file, counsel. I know what he's charged with. Tell me why he's a danger to himself or others.
Because he just killed someone and it's not self-defense. The other individual did not have a gun.
And you know that how?
Because the other individual did not have a gun. He even said to the police, the defendant said to the police.
You've told me all I need to know. You've told me all I need to know because obviously the only reason deadly force is justified is if the other person has a gun.
And what the defendant said. What the defendant said to the police and what his cousin
Your
said.
motion's granted, counsel. The bond is changed to $1 million personal. What's the next court date?
$1 million personal bond.
Thank you, Judge. I've heard your staff say that you were available for exams on August 28th. And our defense is free on that day as well.
28th of August. Does that work for the people?
Yes, Your Honor.
And what time would the be, Judge?
How many witnesses do you think and how long do you think it's going to take us? Because I need to set up pick the scheduling.
I would probably anticipate at least 4 witnesses, Your Honor. And Your Honor, I'm sorry. I know you already made your ruling. Can I just mention one more thing just so the court...
No, because as you said, I've made my ruling. Now we're scheduling the exam.
Okay.
Defense, how many witnesses you think?
I'm thinking 2. Can you hear me okay, Judge? Can you hear me okay, Judge?
I think it's 1. All right. Call it 1 p.m. on August 28th. Good day.
Thank you, Your Honor.
Thank you, Judge.
Had to throw it back in there. That face.
Appearances.
All right. Good morning, Your Honor. Patricia Mandernack for the people, P84088.
And good morning, Your Honor. Robert Joseph, P33195. Here's my right.
What are we doing today, gentlemen?
You know, I discussed this matter with my client, and
All right. Mr. Bonham, you understand your rights and the options those rights give you?
Yes, sir.
And you understand the purpose for an exam?
Yes, sir.
You understand that if you waive the exam, that means your next court date is at the circuit court level, not at the district court where we're currently at.
Yes, sir.
You understand, and understanding all of that, are you waiving that exam freely and voluntarily today?
Yes, sir.
Counselors, are you satisfied with the waiver?
Yes, Judge.
That's right.
All right, I'll enter the waiver. AOI date is going to be 2 weeks down the road, 31st of the month, 9 a.m. Anything as to bond?
Yes, Your Honor, the people would like to address bond.
Currently, my file shows it's 5,000, 10%, no contact, and cannot return to. We all on the same page?
Yes, Judge.
Go ahead, counsel.
Your Honor, I have spoken with complaining witness and she has emailed me several ring videos that I forwarded to defense counsel. Complaining witness indicated that defendant has been coming over to her house, specifically on July 9th at 2 o'clock in the morning and on July 10th at approximately 4 p.m. The ring videos, which I've shared with defense counsel, have they show defendant knocking on the door. And when no one answers the door, defendant goes to the rear of the house where complaining witness indicates her bedroom window is, and he knocks on her bedroom window. Complaining witness indicates that defendant is repeatedly calling her. She indicates that when she arrived at court this morning, she went to park and defendant approached her car on foot. Defendant went to move her car, complaining witness went to move her car to the front of the building, where an officer helped her, watched her park and escorted her in. Complaining witness indicated that at some point during this incident, defendant told her what happened to you not coming to court. She stated that during the incidents where defendant appeared at her house, she was not present for, I believe, the 7-9 incidents at 2 a.m., but she was present for later incidents. She indicates her sister was also present for some of the incidents. She indicates that defendant, that when she did not answer the door because she was at work, I believe on 7/10, defendant was calling her and asking her where the fuck she was at. There was, again, on 7/10, there was another incident where defendant blocked complaining witness into her driveway and threatened to, and I quote, he said, I will, quote, I will smack the shit out of you, or I'm sorry, I will smack the fuck out of you. So based on these safety concerns for complaining witness, I would ask the court revoke defendant's bond and hold him in custody.
Your Honor, this is interesting because the complaining witness texted my client on June 1st saying, trying to get back together, in more crude terms than that. He texted her and says, well, tell me when your company leaves. So then when the company leaves, she texts him and he goes back, he goes over there and he lives there with her for several weeks, almost a month. He does landscaping, he's taking care of her kids. And these situations did deteriorate, but these events that the prosecutor talked about on the first of those events, on the 9th, she texts him and says she wants him back, come over. He comes over, no one's there. So my client kind of had a loss as to you know, it's like go away, come back, go away, come back.
Where would Mr. Bonham get the idea that a bond set by a magistrate in this building could be changed by the complainant?
I don't know. I don't know, Judge. In fact, it's not. My advice to my clients generally is whatever the bond conditions are, that's what you abide by. No matter whether the complaining witness wants you back, if bygones or whatever, because these kind of things happen, unfortunately. You want to know?
Yes, Your Honor. I have no intention on going back. She asked me to come get my things, and I went to retrieve my things, and they weren't where she told me they were. And that is the only reason why I was not going to do it. You know, she asked me to come back.
Half a dozen times you went back to get your things?
No, there's no half a dozen times. I went back.
How many dates did you just give
He's
me?
talking about the ninth.
So I went there on the 9th, but she asked me to come.
In spite of the court order that you not have contact with her and not go back to that address? Just so we're clear, correct?
I understand that, Your Honor.
Go ahead.
She initiated the contact with me, and I thought that we would make amends. And you, as you know, I came before you. In the meantime, from the first when I went back, and she didn't come to court for the other matter that was before you, and you dismissed it because I thought that we were okay. And the only reason we're here today is because I hurt her feelings.
No. That is not the reason you're here today.
No, excuse me, I'm not trying.
You violated your bond condition. Had you not violated your bond condition, her happy, her unhappy, wouldn't have you in this discussion right now.
I understand that, Your Honor.
That's the problem. And see, here's the thing. Quite often when we order a no contact, it's not to protect the victim, it's to protect both parties from each other.
I understand.
Anything else?
I think I say that I'm aware of.
Mr. Bonham, anything else from you?
Your Honor, only thing I ask for leniency. I do understand the severity of it now that I've seen the two, sides come out.
How many different dates do we have him on the ring camera after he was told not to go back?
On the Ring camera, she has not sent me all of the Ring camera yet. I have reviewed about 10 videos so far, and they are for July 9th and July 10th. She indicated there were additional incidents that she has not sent me the Ring camera yet, and also we have.
Well, let's just cut to the chase. What's going to be on those big ring cameras?
On the Ring camera, you'll see me coming and going on. She gave me another key after she changed the locks and we got into it.
What days?
On June 1st, she asked me to come back, and then she gave me another key and granted me access to the home.
Okay.
And whenever I came there, I let her know, this is.
Hold on, I'm just asking you to tell me what days are the ring cameras going to what days will the ring, sir, I know I'm not asking you a very good question, I'm trying to. On what dates will the ring cameras confirm that you were there with her permission?
Every date that she sent, I was there either with her permission or by her asking me to come get my things.
And how many different dates were those?
Where I was there to get my things?
No, where you were there in violation of the bond.
I was living there, sir.
Bond's revoked.
Thank you, Your Honor. I'm sorry, Judge, the AOI date was 7/31/24.
Correct.
Thank you.
And I do need signatures on the waiver.
Thank you.
Yeah, let's do that. Council, we're going to change the AOI till next week, just in case.
24th,
Yep.
24th, is it, what day is?
Wednesday.
Wednesday.
At 9 a.m. downtown.
Thank you, Heather. Good catch.
Well, I have a trial starting Thursday, on Tuesday, so I should be there Wednesday morning.
You can be here Wednesday morning?
No, I have a trial starting on Tuesday in Murphy, so I should be there Wednesday morning.
That means your guy's in jail an extra week.
No, he said, so he's gonna be there too, the trial already starting.
Oh, all right.
Yeah, where do I sign?
Defense, or nope, that's defendant attorney.
It's bugging the judge.
Thank you. Yeah, I know, it's like I'm not finished. Okay.
Here's what bothers me. I believe that he went over there because she invited him. But I got to enforce the bonds.
I tried to write a little bit. I've been making an effort.
I don't doubt that she invited him over every one of those times. And I don't doubt that she's mad at him now. But if I don't enforce this bond, how do I enforce the bond on the guy that is bent on bad?
And for the record, Judge, several of the videos do show defendant it appears trying a key in the lock, and it doesn't work.
It's like, damn, how many times does a woman have to screw you over before you just start ignoring her?
Could you please send me copies of those text messages if you have them?
I don't have it done.
That was an epic quote. Yeah, I believe it too. I believe he was only there because he hurt her feelings. And that's terrible. Shame on her. We're going to take one quick little break because Ava needs a bone. Ava deserves a Grandma Bonnie bone. Now, she's going to be a good girl. And she's going to take this out to the living room and eat it. And not eat it right here. Isn't that right, sweet girl? That thing is really heavy, too. That is as heavy as her head. Yes, a good girl. Yes, a good girl. Yeah, I went back and I looked. Once you said hi to Fozzie in Texas, I went back and looked, and I was sad. They're not here, but they were one that got the gifted memberships from me, so I'm happy about that. Spider-Man, good to see you. Yeah, well, as long as it's not on me, it's fine. These are so cool. They're filled with marrow, and she loves that. She loves that. All right, let's go back to the cases.
Okay.
All right, what are we waiting on now?
Your Honor, if I may, I'm going to speak with the prosecutor, but Mr. Bales and I had quite a breakdown in our relationship, and I just spoke with my supervisor, and I'm going to speak with the prosecutor, but I do anticipate making a motion.
Okay. Appearances, please.
Good afternoon, Your Honor. Nancy Diaz, and I requesting permission under MCR 8.120 to conduct this hearing under the supervision of Attorney Mohammed.
Granted.
Neighborhood Defender Service by Kate DeMott Grady, P83667, on behalf of Mr. Wayne Bales, who's present with us here in the courtroom. Mr. Bales, please state your name.
Wayne Bales.
Thank you. Go ahead, counsel.
Your Honor, at this point, I am moving to withdraw. There's been a breakdown in the attorney-client relationship.
Counsel.
Your Honor, the people are ready to proceed.
We got civilian witnesses.
We have a police officer, no civilian witnesses.
Are you planning on hiring your own attorney, sir?
I was seeing if it was possible to be appointed another.
We appoint, you don't get to pick. We appointed.
Okay, I'll have to then, sir. I'll have to then, sir.
Have to.
Hire another attorney. I'll have to, being that she doesn't wish to represent me.
I don't think she doesn't want to represent you. I think that you probably aren't listening to her advice. That's what my guess is. Usually when there's a breakdown of communication between the attorney and the client, it's because the client's not listening to the attorney.
I understand, sir. When I was on plea innocent, and she didn't want to stand by the innocent aspect of it, so
okay.
I have to.
All right. Well, first of all, innocent, and this is going to sound bad, but it's true. Innocent is not a word that we use in a court of law. It's guilty or not guilty.
I'm not guilty, sir.
I know that, or you'd be already downtown somewhere.
Right.
Okay. So my understanding is there's a preliminary exam scheduled for today.
Yes, sir.
Okay. My understanding is she's prepared to do the, or was when she got here, prepared to do the preliminary exam. That's the next stage in the proceedings when you're pursuing you're not guilty.
Yes, sir.
Following?
Yes, sir.
The question is whether or not you waive the exam and just go downtown and fight the case, or if you go through the exam because whatever reason your attorney might choose to do that.
Okay.
So the question for you is, and that's why I said what I said. My experience has been usually when there's a breakdown in the relationship to the point where the attorney is saying, I can't represent this person anymore, it's because you're not accepting her advice.
I'm just pleading not guilty, sir. That's all.
Okay, and she's told you you can't plead not guilty.
She said it was against her advice, and I should probably hire another attorney.
Was there an offer that the prosecutor made to you?
Yes, sir.
Okay, and has she presented that offer to you?
Yes, sir.
And has she told you that she thought that was a good offer?
Well, that's going against.
Yes or no? Yes or no? Did she tell you she thought it was a good offer?
Yes, she did, sir.
Okay. And did she say, if you don't take this offer, then I can't help you?
Pretty much, sir. Yes, sir.
That's what she said.
Yes, sir.
Okay.
She said that.
Would you like to weigh in at this point, counsel?
Your Honor, I don't really want to get into a back and forth of everything, but I think the court is maybe seeing partly what's going on.
Right.
Obviously, I've advised that it's my duty to fight and follow my client's wishes, no matter whether I think it's the correct choice or not. So I would counter that representation as to what.
Am I correct in assuming you're prepared to hold a preliminary exam?
Of course, Your Honor,
Do
yes.
you want an exam?
If that's what, I'm not sure how the process goes, sir.
Okay, then ask
I'm
questions.
here.
Then ask questions. Here's the way it works. You've been charged with a felony.
Right, yes, sir.
Understood, okay? There's a preliminary exam process in place that if you want, as a defendant, if you want to make the prosecutor prove their case to a certain level so they can get past a gatekeeper like me,
Yes, sir.
then you hold a probable cause hearing. At that hearing, the prosecutor's office has to prove two things. There was a crime committed and there's reason to believe that you had something to do with the commission. That's fairly low standard. But if both of those questions are answered by myself today, by the judge, with yes, then the case moves forward to circuit court level for further resolution. There can be a deal made, there can be a trial held, there can be motions filed. Further things happen at that stage.
Yes, sir.
The other option is the defense attorney and the defendant might agree that based on the facts and the law that we're dealing with on a particular file, there's really no reason to have the exam. Let's just agree that there's reason to send it downtown. We'll go downtown and continue the fight. That's the process.
Okay.
Today was scheduled for that probable cause conference, a preliminary exam.
Yes, sir.
All right. If you want that, she's here to do it. They're ready to go. That's not saying you're guilty or not guilty. It's just saying that's the next step in the process if you choose to go that route.
Yes, sir.
So to say, I'm not going to take an exam today because I don't want to admit my guilt, you're not admitting guilt.
Sir, I just was saying that I was not guilty, and she said that there was she would rather not be my attorney.
There was a what?
I didn't ask her to not be my.
She said what?
She said she'd rather not be my attorney.
Okay, sir, I don't believe that. I mean, maybe there's a miscommunication somewhere. Once again, are you prepared for the exam?
Yes, Your Honor, I am prepared.
He's ready, or the prosecutor's office is ready. I'm not sure who's going to hold the exam. She's ready. If you want an exam, we can do it today.
I'm fine with that, sir. I wasn't saying that I didn't want her as my attorney. She said she'd rather not be my attorney.
Okay, then let's have an exam.
Okay, yes, sir.
All right. Let's get a witness on the stand. Who's the first witness?
Your Honor, before we call our first witness, we are asking a mutual order of sequestration with the exception of the officer in charge as well, Detective Long. And then we will also be admitting a copy of the lab report, this case that shows that the drugs were tested positive for methamphetamine under 76611B.
All right. Anything from the defense on that?
No objection, Your Honor, to either. I'm sorry. Are you just doing a true narc? I'm sorry.
Is that a drug report?
Right, but do you have the MSB drug report?
We do not.
Well, first things first, as to the sequestration
No
order.
objection to sequestration, Your Honor.
Granted. All right. So what do we have for a report? I'm sorry.
Okay, so they just have a true narc scan.
Okay.
I would object just as to that being a preliminary analysis.
Okay. I'm not familiar with the true narc scan. I don't even know what it is. What is that? I don't know that I've ever heard that phrase. That's
yeah. And then just for the record, Mohammed, on behalf of the people, Judge True Narc report is a drug scan that the OIC of the case conducted a test of the drugs, and the analysis of the drug was that the drug that was recovered in this case tested positive for methamphetamine. So it's similar to the MSP lab one, but it's not the same machine. It's not MSP who conducted the test.
It's more like a preliminary test.
Yes, and it was conducted by the OIC.
Okay. All right. So it's actually it's actually an instrument that does a limited of some kind analysis of a substance.
Yes, it's a drug report. The one we're introducing is a True Narc scan report, which is
okay. How long have we been using those, Detective?
Actually, that's what MSD uses now for preliminary stuff.
We purchased our own to save the hassle.
How have I not heard of this before?
Because they always do that other testing through MSP's lab, and that's what's actually admitted in court, so I'm a little bit, I guess I would just ask the people under what authority they're relying on this preliminary test, and also to lay a
Well, stop, you're
foundation.
taking my question. What's the authority for using this instead of an MSP report?
Well, we don't have an MSP lab report, and so this is gonna be used to show that, you know, by probable cause that the drugs that were recovered in this case were methamphetamine.
Okay, I understand you don't have the MSP report. My question is, what's the authority for allowing that instead of an MSP report?
Well, it comes under 76611B. It's a drug report associated with the case. I can pull up the rule and find out exactly.
Pull it up, because I'm gonna have to look at it.
All right.
That's actually what MSP does now. Unless they go through the trials.
Is this the way they're trying to keep up with the backlog? I'm assuming this is a lot faster than full-blown analysis.
40,000 piece of equipment scans over 500 different substances.
Louder for Heather.
It's a device that scans over 500 different substances.
And if you know,
If you can get instant results and it's just as accurate as the lab, and they still can send it into the lab for a double verification if it does come out positive and they need it for some kind of trial. But yeah, that would absolutely help with the backlog. And believe me, in Michigan, there's backlog.
know how many analysis or how many substances can be analyzed in a day or an hour. I'm assuming it's a lot more than the full-blown lab.
It's a pre-test. You scan the substance and you do a post, so you do several a day.
Okay.
I mean, to do one of those, it might take less than 5 minutes.
Okay. All right. Mr. Mongrey, do you have any argument why that shouldn't be good enough for a PC standard?
Your Honor, I guess I would just, my only concern is the reliability of the testing, and there's a reason that, you know, every other drug case I deal with, the MSP lab is what is used, and there's a reason that, you know, departments are sending stuff to a lab for the further testing. So
Right.
I guess that would be my concern, the reliability of it.
Yeah. I'll allow it for probable cause conference. Somebody's got to make the first rule. Obviously, it's fixable at trial.
And just for the record, if it wasn't to be permitted under 76611B, we would just introduce it through the officer in charge, because he's the one who conducted the drug test, and we could lay foundation and introduce it.
I'll allow it for PC.
All right, thank you.
All right. Next issue. Ready for witness?
Yes, Your Honor. The people call Police Officer Mowbray to the stand.
Officer, come on up. Watch your step on my ramp. Raise your right hand. Swear affirm, tell the truth, the whole truth, and nothing but the truth. Settle in. State your name. Spell your last.
Curtis Mowbray, last Mowbray.
Thank you.
Your Honor, may we publish the true narc scan report to the court?
Please.
May I approach?
Yep. Do you have a copy for defense?
I have a copy.
Okay, thank you. Thanks.
Good afternoon, Officer Mowbray. Could you please restate your name for the record?
Curtis Mowbray.
Are you currently employed?
Yes, I am.
Where?
Van Buren Township Police Department,
Are you in any sort of specialized unit?
patrol unit.
And for how long have you been doing this for?
7.5 years in Van Buren Township, 4 years in Roswell, New Mexico.
Okay, and were you employed in this capacity on the date of May 5th, 2024?
Yes, I was.
Did your duties as an officer bring you at or near the location of 50955 South I-94 Service Drive in the Township of Van Buren, County of Wayne?
Yes.
What brought you there?
A male subject, later identified as Mr. Wayne Bales, called dispatch and advised he believed someone had broken into his garage.
Okay, and upon making this arrival, were you alone or were you with any partners?
I was with a partner,
Who was the partner?
Officer McGregor.
And were you in a squad car or foot patrol?
Yes.
Squad
Patrol
car? Okay. Was it fully or partially marked?
Fully marked.
And were you in full or modified uniform?
Fully marked uniform.
Okay, and upon making this location, or prior to making this location, did you do any sort of check on the caller?
Yes, I did. While en route, dispatch advised that during the lean SOS check.
Objection, hearsay.
While en route to the call, I conducted a lean SOS check on my in-car computer system on Mr. Wayne Bales, and it showed that he had several outstanding warrants for his arrest out of our agency.
Okay, and upon arriving to this location, did you make contact with Mr. Bates or Bales?
Yes, I did.
Okay, do you see this person in the courtroom today?
Yes, I do.
Where?
Standing right behind you.
Could you identify a piece of clothing they are in?
Darker colored polo shirt, dark pants,
Okay.
brown shoes.
Thank you. Okay, upon arrival, please tell us what happened.
Made contact with Mr. Bales right at the front door of his garage. He stated he believes someone had attempted to break into his garage because the locking mechanism was jammed with some type of debris.
Okay.
I observed surveillance cameras covering several angles right outside the garage. So I asked Mr. Bales if he was able to enter his garage. He said he was able to clear out the locking mechanism, make entry. He didn't observe any damage.
Okay.
I asked if he observed anybody on surveillance cameras. He said no.
Okay, and you said that running the lien check, he had 6 warrants. Did you place the defendant under arrest?
I
These warrants?
verbally placed him under arrest at that time because further investigation revealed that there didn't appear to be any attempt of a breaking and entering into his garage. So at that time, I advised Mr. Bales that he was under arrest for his outstanding warrants. While speaking with Mr. Bales on scene the whole time, I ended up passing a black Ford Edge with 2 front doors that were open. The hood was open.
Okay.
Believing that was Mr. Bales' vehicle, I advised him I was not going to handcuff him out of respect to him.
Okay.
And he would be able to secure his vehicle.
Okay, so upon seeing this vehicle, what, if anything, did you observe the defendant doing? Did you observe the defendant do anything?
So after advising Mr. Bales that he was going to be placed under arrest and allowing him to go secure his vehicle, I walked right directly next to Mr. Bales. Mr. Bales and I then walked up to the front of the vehicle. I observed Mr. Bales to immediately reach into the engine compartment, in which I observed what he was reaching for. There was several items. One, to be a clear glass smoking device with residue.
Now remember, guys, he's pleading innocent.
Okay, and what else did you observe?
So with that, through my training experience, prior experience and all that, I observed that to be drug paraphernalia. Right directly next to that, I observed a black film container, possibly a pill bottle, but it looked like a black film container, couldn't see through it. So based on my observations, previous experience, I immediately grabbed Mr. Bales and then placed him under arrest for in handcuffs under arrest for his warrants and then that suspected drug paraphernalia.
Okay, and did you recover these items that you observed?
Yes, after placing Mr. Bales in my patrol unit, I then went back to recover clear glass smoking device with residue and that film container, pill bottle that was directly next to it. Upon opening that container, I observed 2 clear plastic baggies with a white crystalline substance inside. Through training experience, I observed it to be a suspected methamphetamine.
Okay, and did you place these items in evidence?
Yes, I did.
Okay, so after placing the defendant in the vehicle, did you transport him to the police department?
Yes, I did.
Okay, and did he make any statements while you were
He
transporting him?
made several open voluntary statements.
What statements did he make?
May I refer to my report to get specific statements?
Yes, you may. I apologize. If it would refresh your recollection, you may refer to your reports.
Your Honor, at this point, I guess I'm going to object to any statements. He's in custody, he's in handcuffs, Miranda clearly applies. There's been no exception established.
Your Honor, he made these statements voluntarily.
There's been no foundation laid to establish that.
We can lay foundation for that.
All right,
Well, that's my objection.
Okay.
just a second. Mr. Woodard, what are we doing on your file? Okay, I just wanted, if it was quick, I was gonna get you out of here. All right, so let's lay a foundation.
Okay, so you stated he was in your vehicle
Yes,
and you were transporting him to the police department?
yes.
Okay, could you tell me what happened when you were transporting him?
While transporting, Mr. Bales made several open voluntary statements to me.
Okay, and did you ask any questions that could have elicited these
No.
statements? You made them voluntarily?
Yes.
Okay, does that satisfy the foundation?
I guess I'm stuck on the word voluntarily. Where are these statements coming from?
I'm not sure if I understand that question. The back seat of the car, I assume.
Understood that, Your Honor. I apologize. I'll make a better point. So he's handcuffed, sitting in the back of a car, and you're saying he's making voluntary statements. I am still lost as to how that's voluntary when Miranda should apply at that point.
Miranda only applies if the officer is going to be asking questions. It doesn't apply when the defendant is just running his mouth.
You want to respond?
Your officer, or Your Honor, the officer stated that he didn't ask any sort of questions that elicited these responses, and that he made these statements on his voluntarily on his free will, on free will.
I'll allow it.
I refer to my report to get specific statements that is voluntarily openly stated.
If it would refresh your recollection on it.
Mr. Bales stated that inside the plastic baggies contained meth. He forgot he had placed the items on his vehicle. He stated he uses meth occasionally, and he stated he only has $400 to his name and doesn't know how he'll pay for the check.
Sounds innocent to me. Someone forgot about their right to remain silent.
Okay, and then let's go back to the items that you recovered and you placed in evidence. Do you know the evidence bag number associated in the weight?
Yes, I do.
What are they?
May I refer to my report to get specific?
If it would refresh your recollection, you may refer to your report.
Evidence bag number Adam 003-604-5330. Original weight 2.1 grams. Weight in evidence bag 6 grams.
Okay. I have nothing further. Thank you.
Cross.
Good afternoon, officer. I'm gonna ask just a few questions. If you don't understand a question, let me know and I'll rephrase. Is that fair?
Yes.
So you go to Mr. Bales' address
Yes.
and you approach this Ford Edge.
No.
At some point you approach the Ford Edge
Some point, yes.
and you said the hood was open.
Yes.
There was a jump pack on the battery.
I believe so, yes.
You said some doors were open.
Yes.
You don't know how that car got there, correct?
No.
You don't know how long it had been sitting there.
No.
You don't know who else had been on the property.
No.
You don't know if somebody had been there right before you got there.
No.
Mr. Bales didn't have anything in his pockets, correct?
He may have had something in his pockets.
He didn't have any, well, I'll ask a better question. He didn't have any contraband in his pockets, correct?
No.
And the drugs you recovered, you said, where did you place them when you recovered them?
In evidence bags.
And where did those evidence bags go next?
Into the back of my patrol unit.
Okay, and from there, where did you bring them?
To the police department.
And from there?
Into evidence locker.
And did you fill out paperwork related to the evidence locker?
Yes.
And you performed no other actions on this case, correct?
Reference to narcotics?
Correct.
No.
No, you did not perform any other.
No, I did not.
And Mr. Bales is in the back of your scout car when you're transporting him to the police department, correct?
Yes.
And he was in handcuffs?
Yes.
Handcuffed behind his back.
Yes.
And your testimony is that you did not say anything to him.
Not that I didn't say anything to him. I did not ask him any specific questions reference the charge of paraphernalia and narcotics.
What did you ask him?
Well, he was asking me questions about where we're going, or without reviewing the video, I can't give you specific questions, but questions that I can absolutely answer with him, to him, without reading him Miranda, because I didn't ask him any questions specifically regarding the charge.
Understood. I don't believe I have anything else.
Redirect.
I just have one question, Your Honor.
Go ahead.
So
Never say that, by the way, because so many times you're going to be wrong. So just say yes, redirect.
Okay, thank you. So the items that you recovered and placed in the evidence bags, do you remember the evidence locker number?
May I refer to my report?
If it would refresh your recollection. Your Honor, may I approach?
See, there's another question.
Evidence
You're
locker
right.
number 5.
Nothing further. Thank you.
Nothing else.
Anything else from the defense or prosecution?
Nothing
Watch
from
your
people.
step.
People rest.
Any witnesses from defense?
No witnesses to defense. Your Honor, I would just note, just for the record, that I understand for probable cause, not the biggest issue, but we do not have that in-car video where these statements were allegedly made. So I would like the court to know that, and I'm requesting that people provide that.
We can provide that information, and if it does exist.
Fair enough.
And if the defense has no witnesses, the people move for a bind over on all charges and reserve argument for rebuttal.
Thank you.
Defense would object to the bind over without argument on the one charge that Mr. Bales is charged with.
Thank you.
Your Honor, it's a question of fact for the trier of fact.
So first of all, I've got to tell you, good job, because I've been trying to teach him to say a reserve argument. So somehow he taught you that without doing it himself. So he's not listening right now. So as long as you're hearing me, thank you. It is a probable cause hearing, and it is a issue for the trier of fact. I will bind over. Mr. Bales, your AOI date is going to be 2 weeks from today at 9 a.m. That's 31st. We'll get you a notice in just a few minutes. No, I keep forgetting. The old way we're saving paper now. I've got a cash bond. I'm assuming bond will be continued. Any argument?
Argument, Your Honor.
Anything else?
Nothing from defense. Thank you.
All right.
Sorry, I did not mean to do that. Someone walked across and hit the mouse.
Bales, good luck downtown, sir.
Thank you, Your Honor.
But it was over anyways. Okay, so this next one, I didn't realize that I left this on here. I didn't edit it. I saw part of it earlier and I was gonna run it, so I had thrown it on there. The previous clip took so much audio editing because every time someone was in the gallery, you couldn't hear anything. And so that consumed all of my time. And I was like, well, I guess I'll just run this one another day. Well, it's here. Hopefully we got it all. I think we do. I'm almost positive we do. So I'm going to run this one, but I apologize that it is not edited. It's not my fault.
Morning.
Good morning, Your Honor.
Good morning. Can you guys hear me? Yes.
Yes.
Good morning. I'm Judge Tammy Long Hayward. This is the 11 a.m. calendar for civil hearings in Clayton County State Court, Courtroom 304. And the first case that I have on the calendar for the 11 a.m. hearings is Alejandra Cano versus Christopher Gerard.
Yes, Mike. Sorry, I was going to say Michael Arndt here for the plaintiff, and our law school intern Barbie Minicata is also on the Zoom.
All right, welcome, Ms. Minicata.
Good morning,
Thank you,
Your
Your
Honor. Apologize. Morning, Your Honor. Ryan Ingram here for Mr. Mingo, the defendant.
All right, so now you all have had quite a bit of traffic with respect to what's been going on back and forth with discovery, some third-party discovery requests, and motions to for protective order, motions to quash, motions to compel. What's going on that we can't play well in the sandbox?
So I think it'll be simple for this morning that the two live motions to compel are plaintiffs' motion to compel and for sanctions against the defendant, and then defendant has a motion to compel phone records that will also be heard. The motion to quash is moot. Those depositions were noticed in June, and defense counsel agreed to not go forward with them. The basis of our objection was that discovery had long been closed, and the court has reopened discovery. So that matter is now moot and we don't need to hear it. So I think it's just the two, and when Your Honor is ready, I can present the plaintiff's motion.
All right, Mr. Ingram, do you have anything on behalf of the defendant that needs to be heard before we get started with the plaintiff's motions?
No, Your Honor, I think all the motions are kind of tied together. I would say that we have a little bit of a disagreement about the motions to quash simply because the plaintiff has indicated they still don't want those depositions to occur. And we agreed to not take them given the court's order. We wanted to maintain the status quo so that Your Honor could hear the motions without anything changing. So we still would appreciate the court's guidance on discovery and those depositions. But I think sort of all this is tied together. So I would welcome Mr. Arndt to address the motions first.
And this is an automobile collision?
Yes, Your Honor.
Yes. It happened August 18th of 2021. Defendant Mingo, after consuming alcohol and marijuana, caused a single car collision. My client, Ms. Kano, was the passenger, and her arm has been amputated as a result of the collision. So for plaintiff's motion for sanctions, we're here because defendant failed to respond to interrogatories for more than a year. The interrogatories were served with the complaint on June 5th of 2023. Defendant's counsel drafted responses that were not verified. Those were served on August 21st of 2023. Plaintiff has repeatedly sought proper answers in the form of a good faith letter on November 2nd. And then there were several emails about the topic, specifically on February 9th, March 1st, March 15th, and March 19th. The basis for our motion is very simple. The statute requires the party to, it says the parties shall answer each interrogatory separately and fully under oath. That hasn't happened. And it hasn't happened, again, their responses drafted by counsel came in 11 months ago, and despite many, many opportunities, defendant refuses to verify the interrogatories.
Okay, one second, Mr. Arndt.
Sure.
Let's separate this. So I don't want to conflate what you're saying. So is the issue that they have not fully responded to each and every interrogatory that you propounded, or is it that they did not verify their responses? Is it that we're dealing with both of those issues, or it's just that we're missing a verification such that they don't meet the requirement of having propounded or responded under oath?
It is both, but the law states that if counsel just drafts responses, that's a complete failure to respond. And the authority for that is Gregory versus King Plumbing, Inc. That's 127 Georgia App 512. That's a 1972 case that has been repeatedly cited to for that proposition. The quote is, "The plain and unambiguous terms of the Civil Practice Act require a party to answer personally his opponent's interrogatories under oath. Interrogatories are not pleadings and counsel cannot answer them." And that's been repeatedly stated throughout the law. So if your counsel just drafts something and you don't swear to it, it's not an improper one, it's a complete failure to respond that warrants striking the pleadings. Defendant's response is, you could have asked our client all of the interrogatories in the deposition. That has been addressed by the Court of Appeals. The case is Porter versus E Airlines, Inc. That's 165 Georgia App 152, and it's at page 155, and that's a 1983 case. And the quote is, "Appellants further argue that the interrogatories were answered at a deposition. Interrogatories served on a party must be answered separately and fully in writing under oath." And that's a Court of Appeals case affirming a sanction for a party refusing to verify their interrogatories.
Yeah, generally, when people go to depositions, they're using the interrogatories to either verify or box in the person that they're deposing. And so, yeah, I get that they're separate, and the requirement is that they be separate.
And that's right. And so defendant tried to supplement their interrogatories, still not verified, and counsel just went in and would try to cite to pages of the deposition. Many times this wasn't actually responsive to the interrogatory. But as you point out, the whole purpose is that you try to get them under oath to get their position. And then there's the potential for impeachment. There's the potential to confirm details in the deposition. It's just improper to refuse to do so. So I think the intent to disregard the obligation is very clear in this case. Like I said, it's not one where we rush to the court, that there were multiple communications, and instead of just verifying them, which would still, the court could still issue sanctions after a motion has been filed. But instead of doing that, we now have a brief, a response, a reply brief, a whole bunch more motions for the court, and they just can't do the basic thing that they were supposed to do in August of last year. So I think the intent is clear. And the last point of how we know that it's intentional is there was a second set of interrogatories that related only to our 9/11/68 offer. We send 3 short interrogatories after a 9/11/68 offer has been rejected, just to make sure that if we get an excess verdict and are trying to collect the attorney's fees under the statute, that there's no argument that it wasn't properly served, all that sort of stuff. So that was our second set of interrogatories, and they verified those. So they're aware of the obligation. They've been repeatedly reminded about their obligation of the first interrogatories. And I've never seen a case where a party just refuses to do so for more than a year.
Mr. Arndt, let me ask one more question. Is there a pending criminal case in this matter?
No, it's in pre-indictment. So we can't get a lot of the police's file as a result of it, but there's no actual case.
That's actually not the reason I asked. Mr. Ingram, is the lack of a verification related to a Fifth Amendment, I guess, desire not to incriminate oneself? Can we flesh this out as to why we can't get a verification?
Well, Your Honor, first, I believe that the verification we execute, or my client executed, that Mr. Arndt referred to, refers to all
the second set of interrogatories.
I believe that verification refers to all interrogatories in the case. That was certainly my intent as the lawyer for that to apply. And second, yes, Your Honor, there is a Fifth Amendment issue. There's an ongoing criminal prosecution that's still open.
Did you let Mr. Arndt know that that was the issue with respect to the verifications that he was requesting?
I cannot sit here and tell you with certainty that I did. I know that we've asserted that Fifth Amendment privilege a number of times in the case, and I'd be happy to go look at our correspondences. I'd be shocked if I didn't. That's just not something I looked at this morning, so I certainly don't want to misrepresent to the court.
Well,
in fact,
as someone who practiced civil litigation but prior to taking the bench, but who's had quite a bit of criminal experience since taking the bench, that's kind of the reason I ask these questions is sometimes there are two competing themes. And if there are criminal matters that are pending, I always look to what the constitutional rights are of the person who's going to be a defendant in that criminal matter and how that balances with the civil matter. We probably could have instituted a stay or done something similar to preserve the issues, but to kind of let the criminal play out if that was what the competing issue is. But you gotta kind of discuss those things, because Mr. Arndt, if he's not a criminal attorney, that's not going to be uppermost on his mind. He's thinking, I have a plaintiff who needs to have redress for what is a catastrophic injury.
Your Honor,
can I just address those very briefly?
Sure, Mr. Arndt.
The defendant did not assert the Fifth Amendment in his answer, and in all the motions that are pending before the court on this issue, the Fifth Amendment isn't brought up once. So I think Your Honor is suggesting a reason that was never offered. And if I can share my screen on the second.
I'm not trying to tell him how to respond. What I'm asking is if that was the case, because if it were the case, there's a different set of decisions that I need to look at versus if it wasn't. But if it was never mentioned, then Mr. Arndt has gone through a lot to secure a verification, which we could have simplified all of this. And so while me forcing you to do a verification might not be appropriate, sanctions might be.
And I can show you the verification for the second one. It very clearly states that it's for the second interrogatories, if that's okay.
Thank you. I was going to request that next.
Can you see my screen, Judge?
I can.
So here it is, defendant Christopher Gerard Domingo's responses to plaintiff's second interrogatories.
Yeah.
So
that's not an omnibus verification, Mr. Ingram.
Yeah, you're correct, Your Honor. I stand corrected. That's my mistake. I just assumed, and I apologize.
Yeah, I'm one of those people who is from the old school with civil. If we can be as open and direct as we can be during discovery, it helps the case come together a little bit better. If I can see that there's maybe some competing issues with respect to the defense, even if it's in a pre-indictment stage, Mr. Arndt, it doesn't erase Mr. Mingo's right to preserve his constitutional rights under the Fifth Amendment. However, a little bit of candor would have kind of cut out all of this back and forth, and we could have structured it a little bit differently so that you're not continuing to seek something that you weren't going to get at this stage in the proceedings. Because I don't think I can force, verification is required, but I don't think I can force under the OCGA him to verify interrogatories that might, under the United States Constitution, jeopardize his right to a defense in the criminal case.
And to that point, it is his personal right, and he can absolutely assert it. He just hasn't. Like I said, that he didn't put that in the discovery responses. He didn't put that in any of the motions. He didn't put that in his pleadings. So if his answer is, I'm refusing to do so under my Fifth Amendment privileges, you're right, we're stuck with that. But that's not what's happened, and this isn't coming up for the first time today. That this is, like I said, something that we've talked about an awful lot in following depositions and emails and motions, and not once has Mr. Mingo suggested that that was the reason. There's never been a reason suggested. They've just said, hey, we don't have to do that, and that's just contrary to the law.
Is the criminal case pending in my county?
No.
It's in DeKalb. It like I said, it's pre-indictment, but it would be DeKalb.
And Your Honor, if I may, first, you are correct. After I took criminal law in law school, I said I never want to touch anything criminal again, and it's not in the forefront of my mind. I'll acknowledge to the court, I don't know anything about criminal law. I will also tell the court that I was not aware of Mr. Mingo's representation by a criminal defense lawyer until just shortly before his deposition. And my job is to represent Mr. Mingo, and so that's what I'm here to do. But I also want to be clear with the court about the facts as I know them. And that is when I learned about it.
Okay. Go ahead, I'm sorry.
The other thing that I just wanted to say, Your Honor, is, this is an awkward position for me personally, simply because the way I practice law and civil litigation is to try to avoid motions in situations like this, if at all possible. I was taught litigation is supposed to be face-up poker. We all have the same information, and we let the fact finder make a decision, and that's the way we operate. I don't think Mr. Arndt is suggesting that we just didn't respond on behalf of Mr. Mingo. We did. We asked Mr. Mingo to provide us with information. He provided some information, and we've provided everything that we have received from our client that's responsive to the discovery requests to the other side. We're not withholding anything, and we've informed Mr. Arndt of that, anything that I personally as the lawyer am in possession of. I would also say that, we did inform opposing counsel multiple times, like I said, that we're not withholding anything. I do believe the Fifth Amendment has been discussed in the case, but again, not until around the time of Mr. Mingo's deposition in March. And at the time that I learned that it needed to be asserted, it was asserted in that deposition. I would also say, Your Honor, that there's some more information that I think the court might benefit from being aware of when evaluating the pending motions. The plaintiff has asserted this is a simple case and they're ready to try the case. We disagree because we haven't been able to conduct multiple depositions of some fact witnesses and impact witnesses. But the plaintiff's assertion that this is a simple case seems to be at odds with the plaintiff's claim that they need more information from Mr. Mingo. And that's specifically at odds with what we learned during the plaintiff's deposition, which is that the plaintiff and the defendant maintain a romantic relationship today.
I don't think any case is simple. I'm just going to say that. And for two, so what if they maintain a relationship? It was a car accident. She unfortunately lost an arm. She can't get that back. It doesn't mean that she has to break up with him, but it also doesn't mean that there's not responsibility or financial reimbursement that needs to happen.
And that's something that I learned in the plaintiff's deposition, that the plaintiff and defendant had dinner the week before the plaintiff's deposition. Ms. Cano also testified that
So do her claims of damages in a car accident go away because they are romantically involved? I'm kind of unclear as to what statute that is.
No, Your Honor. The point though is that, to the extent the plaintiffs claim that they need information from Mr. Mingo, we know as a factual matter, they talk all the time, at least according to the plaintiff and the defendant.
But that's not how this goes. I can talk to my neighbor over the fence, but if he sues me about a tree that's about to fall on his property, our attorneys are going to talk. Even though we're still talking, I can still lend him a cup of sugar. Our attorneys are going to talk, and they're going to go through the formal process of figuring it out. So the fact that they're still related romantically, neither here nor there. What we need to do is follow the Civil Practice Act and gain the information necessary to litigate this case through the rules and procedures under the Civil Practice Act. And so, with that being said, we need to respond to interrogatories when they're propounded. I mean, if they're still good together, that's fine, but seems like the plaintiff doesn't really have any way of kind of pushing the defendant to come in and sign a verification or meet with you to determine what's necessary to go forward in the case. And so if that's the issue, then we have the romantic relationship is not having any bearing on the civil litigation. The second thing is, my understanding is that there were motions to quash for third-party individual, entities, but I granted the additional time, thinking that would take care of that issue. But if there are still reasons that those parties can't provide information, then I need to know what those are if we're going to fully resolve all of the discovery issues.
And Judge, I can short circuit that one. So Mr. Ingram was seeking two depositions. It was Arsheen and Miss Gruwall. And when discovery has been extended, most of our objection has gone away. We have told Mr. Ingram we don't intend to call those people at trial, and we can make that a stipulation if that matters. But we don't have a basis to oppose their depositions anymore. So like I said, we don't think it's necessary, but we don't have a basis for a protective order. So that one is off the table.
It's their dime. So it's even if you don't intend to call them, the purpose of discovery is to what could lead to information that could be produced at trial, not as necessarily going to be produced. So they have a thought about what these two individuals could add to their litigation, then I'm fine with them. So we'll go ahead and get a schedule going so we can get them deposed, even if I have to extend discovery further out, so we can make sure that once we get back to the stance of being ready for trial, we don't have any outstanding issues. So that's taken care of, Mr. Ingram. Is there anyone else?
Yes, Your Honor, the defendant's motion for production of records from AT&T, they would be the cell phone usage records of the plaintiff from the date of the origination of their relationship until the present time. And the reason for that request, Your Honor, is that the plaintiff has asserted a claim for punitive damages. And to the extent the plaintiff intends to assert to a jury that Mr. Mingo should be punished, any change or lack thereof in their relationship is potentially relevant for the jury to consider. When the plaintiff says, you know, I'm upset with this guy and he should be punished under the law, if their relationship continued in the same manner that it was prior to the accident, that's something the jury should have the benefit of knowing when evaluating that claim. And so that's the reason for the request, Your Honor. We've offered as a compromise to make the same
And you want
request.
whose records, your client's records? Whose records are we asking?
The plaintiff, Your Honor.
Okay.
And we've offered as a compromise to request the same records of both the individuals out of simple fairness, Your Honor. But if the plaintiff is claiming that the jury should punish Mr. Mingo as she is, then the fact that her relationship has either not changed or changed would be potentially relevant. If she decided we don't need to see each other anymore and I don't want anything to do with you, the jury should know that. But similarly, if Ms. Kano decided, you know what, despite the accident and what occurred, our relationship should continue or even become more frequent, then the jury should know that. Certainly up and through the time of trial that they're asking a jury to punish Mr. Mingo. And so that's the reason this is the best possible evidence to show the nature and extent and frequency of the communications between these two individuals from the time of their relationship as it existed at that time, which Ms. Kano testified to, and then as it existed afterwards. As an example, we know.
Would this just be contact information or content information? Are we talking about how many times they've called each other or when was the last call versus any text messages, content, that kind of, not that I know whether they keep it. I think they keep everything, but hey, that's just me.
I agree, Your Honor. I agree. I assume everything's kept, but no, Your Honor, we're not seeking content, just the nature or excuse me, the frequency of the contact, whether calls and duration of calls and the time and extent of text messages between the two. And it would be potentially relevant to see if that communication stopped for a time period and then restarted, and when in relation to the plaintiff's filing of this lawsuit that occurred. And certainly if it's less, then that would tend to be consistent with plaintiff's claims that Mr. Mingo should be punished. If the frequency of contact between them is more after the filing of the lawsuit or after the incident, then the jury should know that they talk even more after the incident. That's potentially.
Is there some case law that supports what you say? I get it from the standpoint of how to proceed from a trial procedure standpoint, but from the standpoint of helping a judge determine how relevant that information would be, is there case law where, you know, a plaintiff and defendant remain romantically linked and during the course of litigation?
Your Honor, I haven't found any case law specifically on that point, but I would say as the court is aware, and as you mentioned earlier, discovery is broad, and if it's not relevant, we can exclude it at trial. I'm not asserting that all the information we may gain from these requests is relevant. I don't know until I see it, but I just think that the jury should have the opportunity, if it is relevant, for us to present that information to the jury.
All right,
And
Mr. Arndt.
that's just basic
Oh, I'm
discovery. I apologize, Your Honor.
Yeah, I got you, Mr. Arndt.
So a couple things. One, the basis for our punitive damages claim is Mr. Mingo's decision to operate a vehicle at 4 times the speed limit after having marijuana and alcohol. So as specifically as possible, and this is quoting from the complaint, defendant was operating his vehicle in a reckless, negligent, malicious, willful, and wanton manner. So several of those are the predicate for punitive damages, but it's the operation of the vehicle that is the punitive claim. Whether or not defendant and plaintiff had romantic relations, they were dating exclusively, not exclusively before, they've had dinner since, is completely irrelevant to plaintiff's claim for punitive damages. The punishable behavior is the way that he operated the car and how many times they've talked in the 2.5 years of records after the collision that defendant is seeking is totally irrelevant. So that's the first thing, is I think they misunderstand what the punitive claim is. It wouldn't be evidence for us if they had never talked again to say, see, plaintiff is red hot angry at defendant, and that's why you should issue punitive damages. That wouldn't be an argument for punitive damages. Likewise, the opposite of saying they have talked, they have gone to dinner after going through this traumatic event together. That's not evidence either as to whether punitive damages should be awarded. Sorry,
I would assume that that's information that's going to come up at trial. There's nothing that would prevent either one of them from answering a question about whatever the state of their relationship is.
Potentially as background, but he was making it sound like it was a substantive inquiry as the punitives, and I was just pointing it out. But you asked for law, and in our briefing, we provided federal authority.
Okay. Yeah, I'm open to anything at this point because I'm pretty sure that if there was a pinpoint site or a case that had it, I'd probably have it by now. But I just
the quote, and this is from the Southern District, where they found requesting multiple years of phone records, quote, can easily cut very personal, which is overbroad and unacceptably annoying. The court thus grants plaintiff's motion to quash on that score. And that's Martinez versus Rye Cars Construction, LLC. And it's in the brief, but the site is 2010 Westlaw 411-7668, and it's at page 2. Another one very similar, seeking several years of phone records, and the quote was, clearly is overly broad and not limited to relevant and discoverable information. So I can't imagine a case where we would ask the court to compel the defendant to say, every person that you've communicated with on the phone, with a phone call or text message, even if we had you're using your phone a lot when you're driving type claim where it could be relevant as to what you're doing with your phone.
That was what my question was pointed at, because generally those requests are overbroad unless they're really kind of confined to immediately before and immediately after the incident.
And to that point, that was our proposed compromise where we said 3 years of absolutely all calls, all texts, all data usage is way overbroad. We'll give you the day of if you think that's relevant for something. We don't think it is. Again, she was a passenger. It wouldn't matter if she was on the phone. But we did that as a proposed compromise, and they didn't engage with that they want the whole shooting match. So again, 7.5 months before the crash and 2.5 years after. I've never heard of such a thing. And their stated reason seems to misunderstand the punitive claim that we're making. The punitive claim is your decision to drive at 4 times the speed limit is a conscious disregard of the safety of others. It has nothing to do with who you talked on the phone with.
Is there any other part of the punitive? Is that the sole claim under punitives, or is there anything else that fleshes it out anymore?
The potential substance abuse before driving is related, but no, it's exclusively how he was operating the vehicle. Yeah.
All right, Mr. Ingram.
Your Honor, I would just say that the court's well aware of the pattern jury charges that the court gives on punitive damages. Punitive damages are authorized to punish or deter future conduct. And in this case, I agree, it is a rare case where a request for records this broad may be relevant, but here it's reasonably calculated that there may be discoverable and relevant information in those records. I would say in terms of the plaintiff's concerns, we'd be happy to not receive any records other than records of communications between the plaintiff and defendant. I'm not interested in anybody else's communications or the plaintiff's communications with anybody else. But again, to the extent the plaintiff is claiming that the jury should punish or deter future conduct, it's potentially relevant for the jury to understand the nature of their ongoing relationship, whether it is increased or decreased in frequency. And as an example, Your Honor, I learned during Mr. Mingo's deposition, after plaintiff's deposition, she testified that she had taken Mr. Mingo to a dental appointment the day before her deposition. And about 30 minutes after that testimony on the record, we received a communication from Mr. Mingo that because of dental work he had recently received, he wouldn't be able to appear that day for his deposition. About a month later, we finally had Mr. Mingo's deposition, and we learned in that deposition that she did in fact pick him up and drive him home from that deposition or that dental appointment. That puts both of these parties in a car together. That's potentially relevant information. And again, that's only borne out by the nature of the relationship and the ongoing relationship. And again, it may not be relevant, Your Honor. We may not need to present that information at trial, but if the plaintiff continues to associate and drive or ride with the plaintiff, or excuse me, with Mr. Mingo, the jury should have the benefit of that knowledge when deciding whether the plaintiff is correct in saying that Mr. Mingo's conduct should be punished and future conduct similar to what happened on the date of incident should be deterred by these punitive damage claims.
Okay, if the punishment we want to deter is not his association with the plaintiff, but the punishment, the conduct of driving too fast and drinking and partaking in illegal substances and driving, if that's the conduct that we want to deter by punitive damages, nothing in the AT&T records is going to make that true or not true. I mean, if you want to deter them from having a relationship, or that's an entirely different track. And whether he gets punished or not punished, I think that the argument that I'm seeing is, hey, jurors, give her less money because she's still associating with the person who drove and took her arm, as opposed to he's, the punishment, the punitives are for the way he drove and what he, consumed while he was driving or before he drove. And so that's a different argument. I don't know that AT&T records are going to lead to anything that helps you to defend against the punitive claims with respect to how he drove and what he consumed before driving. And so with respect to that, I can tell you now that the AT&T records are not going to have to be produced. We'll go ahead and.
I apologize. I'm sorry, Your Honor, I was just going to say
it's a fishing expedition, Mr. Ingram. And I mean, mind you, I've done my fair share of of civil defense, but it's an argument if you want to make it, if it comes up in trial and you want to make that argument, hey, they're still seeing each other, they're still talking to each other. Those are questions that can be elucidated at trial. But the issue that we have here is whether the AT&T records are going to lead to anything that could be relevant. And in the broad use of my powers of discretion over these discovery issues, I'm not seeing it. And so the argument can still be made if it comes up in trial, but I don't know that we need to do 3.5 years of AT&T phone records to verify that they still like each other. And in another context, I hate to say this, but it tracks with what I know about, and I'm not saying this is an abusive relationship, but in abusive relationships, there can be all kinds of injuries and damage, and they still see each other. And so I don't know that it changes the level of damage or the type of damage or how the damage was done, just to know that they're still together. what we're trying to, what punitives would deter in this case is Mr. Mingo allegedly, all this is alleged because we haven't gone to trial yet, nothing's been determined, but him essentially imbibing in illegal substances and overuse of alcohol and driving in a way that could hurt anyone, not just this particular person who was riding with him. So
Thank you, Your Honor.
I just think that it's overbroad, and I don't know that it will lead to anything that will assist you with respect to that based on the arguments you've made in writing and today. Now, I think we're back on track. I think that we, Mr. Ingram, I'm going to give you 10 days to get with Mr. Mingo's criminal attorney, and you're either going to assert the Fifth Amendment in writing and explain what you can and cannot do based upon that Fifth Amendment right against self-incrimination with respect to the civil discovery that has been propounded, or you're going to verify the first set of interrogatories.
Yes,
and Judge, can I just clarify that? Two things. One, can we have the objections removed? As an example, our interrogatory number 5 just said, in the 24 hours before you drove, tell us if you were on medication, any illegal or legal substances that you took, and their objection was that this is protected by HIPAA, which is obviously wrong.
Yeah, that's
so
not,
again,
because if I did a search warrant, that wouldn't be protected by HIPAA, and if it comes up in the criminal case, while it may be protected until the criminal case goes to trial, it's gonna be public at some point. So HIPAA's not gonna protect what his blood alcohol level or level of intoxication from any substance is. So no, yeah, let's update those. But if the response has to be that a pending criminal case and Fifth Amendment, then fine, but make sure that the record is clear and correct.
Sure. And that's all I was going for. So we'll either get a Fifth Amendment, I can't answer because of the Fifth, or we'll get a clean answer
Yes,
within 10 days. Gotcha.
Yes, and if you get a clean answer and there's no Fifth Amendment, say the case goes away between now and then, I don't know, I'm not a district attorney and they have the right to prosecute, but then you'll have 10 days to either give clear answers that this is Fifth Amendment protection, or you're going to verify the first set of interrogatories. Now,
Your Honor, if I may, to be clear, as to objections, if there are other objections that are appropriate as to breadth and scope and things like that.
yeah, make them.
Okay, thank you. Your
Yeah,
Honor.
but just be clear about it. You know, I don't know that HIPAA, because we can get around HIPAA. I don't know that is not a end all and be all in a discovery issue. But if there are other objections that need to be asserted, please make sure that you assert them. But if the main reason we can't get a verification is because of the Fifth Amendment, then make sure that's asserted and Mr. Arndt is not left in the dark as to why this case is not moving forward as quickly as it could. Now, all
right, I'm going to pause it right there for just 1 second. With motor vehicle accidents, you have 3 years to file the lawsuit. It takes forever, and the reason is, and I'm finding this out because of my own case that's we're currently in the process of getting all of the discovery for the case and everything. But the biggest reason that it takes so long is you have to be at complete healing or as much healing as is going to occur, especially when there's an injury. So, for instance, she lost a limb, but what if, after they did that surgery, in the process of, in the process of her recovery or something, let's just say she got some kind of a fungus or bacteria in that was not outwardly visible, and they go to trial and they settle or whatever, and then all of a sudden, like 6 months or a year after, it starts turning necrotic or something, which actually, believe it or not, it does. I'm not like making this up out of the blue. There's a show called Monsters Inside Me, and I have seen some stuff. Sometimes issues don't present immediately. My spinal issue took, golly, it was a very long time before it presented, in a way that we knew it was a spinal injury. It presented as other things that they didn't understand, and it took a long time to figure it out. But yeah, they have to make sure that you have done as much healing as you're gonna do. And then it takes another like 6 months or more to get all of the medical records. The lawyers have to go through all the text messages, all of the statements, all of the everything. So yeah, it takes a long time. But yeah, 3 years, that is if you do not file the lawsuit by 3 years, that's like the statute of limitations kind of thing on it. That's why it takes so long.
Respect to the Art Sheen and Gruel, if you want to depose them, notice it within 45 days of today's hearing. If you don't want to do it, then fine. Then y'all go ahead and knock those out. And if at any point we get to a situation where the case is stalled because there's a criminal matter pending, and y'all want to, let's stop the case here at this point. Let's see what happens with and it may benefit you too, Mr. Arndt, because a lot of times people will wait to see, and if it's a conviction, it helps plaintiffs. If it's a acquittal, it helps the defendant. So y'all both may benefit from something like that. But if that is the case, let's go ahead and have a little telephone hearing or a little Zoom conference, which is not necessarily a hearing, but let's talk about it. Let's see how we can best move this case forward without having to go back and forth with a lot of motions. Okay?
Sure, Judge. And I hate to do this, but just one more thing, that a problem that we have in this case is what I think is going to happen because of what they've produced is they will say things like, and this is a quote, "We have already produced all non-objectionable responsive information," without indicating what is being withheld for that non-objectionable. Tell us specifically what is objectionable. So if they say, you asked for 5 years and we only think 3 years are discoverable, it's very clear that we're withholding 2. That's fine, and we can discuss that, and if we need to bring it up, that's fine. But when you say object to every single discovery request as they have, and then say, we've given you all the non-objectionable stuff, we have no idea where we are, and we have no idea whether knowing if we have the whole universe, whether they're withholding a little bit, a lot of stuff. If their answers don't make it clear, it's impossible to know where we are. So I understand that they're not going to give straight answers to everything without any objections. My only request is that it has to be very clear what is being withheld, so we know if we even need to argue about something or not. And without that, we just have no idea of where we are.
We agree completely. And as I said, we're not withholding anything. And I believe very strongly as a lawyer, we have an obligation to make sure the other side is aware if we are. I'm not a hide the ball person. I think that's totally inappropriate. And we will make clear if there is something being withheld. I don't expect that to be the case because as I've explained multiple times before today, we are not withholding any information pursuant to our objections. We simply have an obligation to defend Mr. Mingo, and we have done that by objecting when appropriate.
Okay. Well, I trust that you both know the Civil Practice Act, and I want to make sure that the responses are clear and are complete, as complete as they can be, because otherwise we're just going to spin our wheels. Mr. Ingram, I can't tell you what to do on behalf of your client, but I do you know, the suggestion has been made that you speak with his criminal attorney, because as you've pointed out, that's not your bailiwick. So you may want to get direction, because there may be some things that, you know, can be produced based on what's already out there. The police report is already going to be out there. Any information that the investigators have already given in maybe a preliminary hearing or something like that is already out there. So there may be certain things that may be produced by your client or other parties that you all can say, well, you know, this is already out there. But as for what my client responds, you know, and then say your objections. So I trust that y'all are going to be able to get that done, and we'll move forward. So this is what my order is going to look like. With respect to the plaintiff's motions to compel, the motion to compel for the phone records is, sorry. Okay, so the motion to compel the AT&T phone records, that's denied. The motion to compel for the verifications of the interrogatories, that's granted to the extent that the Fifth Amendment right against self-incrimination will be asserted where appropriate, or a verification will be given if the Fifth Amendment right against self-incrimination is not asserted within 10 days of today's date.
And Judge, just the as for the depositions, in hopes of avoiding involving the court again, our concern is at Ms. Cano's deposition, there was a lot of talk about her sexual history. She's a woman in her 20s. I don't think that's relevant to anything. We're not claiming that she can't have sex or anything like that.
I hope not.
Yeah, so they asked if she had sex on Christmas, whether she had sex in her family's bed, whether she received she had to give anything in exchange for all the money. So I don't want any of this coming up with the witnesses. And if we can get a stipulation on the record, I promise we won't have to come back to court, but we really don't want to go there. And we've tried talking about it. We think it's completely out of bounds and it should be not brought up in the deposition.
She lost an arm, not her libido. What, I mean,
Your Honor, this is Your Honor, I have tried to not, these cases are about the parties, not the lawyers, and I have been repeatedly attacked. I have been repeatedly attacked. It is untrue what Mr. Arndt just said. The word sex was not in my questions, but the nature of their relationship before and after the incident is potentially relevant. And I did ask if they maintained a physical relationship before the incident and after the incident. This assertion that I asked her specifically where they had sex or anything like that, completely false, Your Honor. And I object to the personal attacks against me.
So I want to be real clear on that. So hang on one second, Judge, and I hate to interrupt. The question of, did you share a bed with him and are you still physical? Those were exclusively about sex. And the fact that you didn't use the word sex, the court reporter afterwards commented about how inappropriate it was for a middle-aged man to be asking a 20-year-old about her sex when it has nothing to do with the case. It's not like we created it, and we've brought it up multiple times, and all we're asking for is a stipulation that is out of bounds and should not come up to try to harass and intimidate a 20-year-old in a deposition by intimidating her friends and talking to her friends about her sex life. Completely out of bounds, and all we're asking for is the stipulation. The deposition is in the record where those questions were asked. Why were you initially attracted to him? All of those things, nothing to do with anything, and we need to put a stop to it. Was the only reason we brought it up.
It's entirely inappropriate, the innuendo that's being thrown at me, Your Honor. I'm happy to review the entire transcript. They are appropriate questions necessary for me to ask. And Your Honor, let's be honest, this is a unique case. I have never defended someone where they have an ongoing relationship with the person they've sued. And I, as the lawyer, am having a difficult time getting information to respond to discovery while there's communication going on between the parties. It's a very strange situation, Your Honor, and I'm doing the best I can to represent Mr. Mingo.
I got it, Mr. Ingram, but Mr. Ingram, you've not knowingly represented anyone who had an ongoing relationship. A lot of people do, and they don't tell you.
That's fair.
Number one. Number two, I think that this is more of a normal case than you're letting it out to be. What we're dealing with here is a catastrophic injury with respect to a one-car accident, collision. There's nothing more normal than car accident cases. I mean, that's the bread and butter of civil litigation. And so from that standpoint, whether she's having sex with somebody, who she's having sex with, if it's not, I mean, if they weren't having sex in the car at the time that the incident happened, I'm not sure that it's relevant, because we've already discussed the fact that they have a known romantic relationship. And so now that you know it, you can go ahead and assume they're doing everything under the sun and let that be it and work from that. But Mr. Mingo is as much involved in this case as is the plaintiff. And I'm not sure why her sexuality is any more necessary to review than his. Mr. Mingo hasn't, I believe, been deposed. Is that correct?
He has, Your Honor.
He has?
Yes, Your Honor.
Okay. And did we go into whether he was having sex or who he was having sex with?
Your Honor, similar to Ms. Kano, nobody asked them about sex.
Or, okay, a physical relationship.
Frankly, I wasn't there, so I'm not sure what was asked of him other than generally about the car accident.
Okay. Well, I just think that strains the bounds of what is relative. Yeah. Unless he called you 12:30. Thanks. Yeah, that strains the bounds of what is relative in this case. I mean, relevant in this case. And so let's just, if y'all have to come back to me and we have to have an in-camera frank discussion about what's necessary to talk about. But with respect to a 20-year-old taking a deposition probably for the first time, those types of questions can be somewhat intimidating. And I don't know that they're necessary to lead to information that's going to be presented to a court and a jury. I just think we have to be mindful of those things. We haven't, there was no attempt to find out if Mr. Mingo was still sleeping with the plaintiff. I mean, so if the reverse is not necessary, then I don't know that that's necessary. I don't know that it helps in any way to move this case forward. So let's just, I don't know who Art Sheen is, who's Miss Gruel, who are these individuals? Let's get into that before y'all have to call me to certify a question or something.
Your Honor, these are simply Miss Kano's friends, who she said she associates with more than anyone else. And we anticipate they're going to be able to tell us about the impact on her life of this accident.
Okay, well, then we should be asking about how she gets around with an arm missing as a 20-year-old, as opposed to, whether she and Mr. Mingo are still doing the tango, horizontal or lateral.
Your Honor, there's never been an intention to ask them about that.
Okay, all right. So let's go ahead and get those depositions set up within 45 days. And then if there's anything further that needs to happen in this case, you all can email Miss Powell and she can put it before the court, okay?
Thank you, Your Honor. Yes, ma'am.
All right.
Thank you, Judge. I appreciate the time.
Thank you very much. Miss Minikata, turn your camera on for me. You still there?
There we go. You're on mute.
Oh, there we go. Hi.
Yes.
Thank you for letting me join and listen in.
It is my pleasure. I don't see many young law students. By the time they get to me, everybody's been practicing for a while. So I wish you well in law school. I hope that you have enjoyed your experience in this hearing and interning. And all I say is be open to all the possibilities that this being an attorney allows you, because it is probably one of the most open fields that you can get into.
Yes, ma'am. Thank you.
Right. Take care.
Thank you, Judge.
All right. Thank y'all.
And I do not believe Ingram when he says that it was not intentional to ask her about it. No, Ingram, you look like the type of guy that it would be completely intentional to ask a 20-year-old girl about it. Yeah. I told y'all. Just stick with me. Y'all just gotta trust me. I find this stuff and I'm like, oh yeah, I know it. My chat's gonna love it. Oh my gosh, that was so much fun. I'm sorry it took so long to get to the tea. But it sure spilled. The judge's face was beautiful. It was perfection. Oh, she could not believe what she was hearing. I want to see that depo transcript. I want to see. I don't believe Ingram. Yeah. Oh, I don't like them. Yeah. Oh, I think Ava almost has her bone depleted of the marrow inside. Yeah, you got that. You got that face. You got that face. Oh, that face. So beautiful. Yes. You're so beautiful. How's that bone? How's that Grandma Bonnie bone? Did you make sure to drink lots of water? Yep. Yes. I was telling Finna 7 earlier all about my amazing mods and my amazing subscribers. And I kid you not, I have the absolute best, and I mean it, best mods and best subscribers, best members in the whole world. And I can say that. It's true. Oh, thank you, Sir Philip. I was so happy when I found those with Judge Oakley. But then, like I said, it took so much editing for the audio. Auntie M called me, and she's like, do you got a time estimate? I'm like, the best I can do. I'm going to try. Oh, anyways, guys, thank you so much for coming out, for all the laughs. Oh my gosh, you guys are so stinking adorable. I love every one of you. I couldn't be more grateful. And I hope you all have the most amazing night. Oh my gosh, sorry. I needed to take a drink. My mouth was so dry. Big things coming, guys. We're gonna have a little team meeting tonight, and we got some things to discuss. And I promise it's gonna be great. Oh my gosh, you guys are so amazing. Today That was today. I love you too, every single one of you. Oh my gosh, yes. I love watching it. Yep. Can y'all hear her? That's that bone on bone scraping sound I was talking about that I can't. I just, ooh, my brain. Yep. That bone and that dog are going to go outside, and only one of them is coming back in the house tonight. Yeah, there were 2 304 hearings today that I saw. I got them both. But this one was on there. I'm so glad that it didn't have like long breaks or anything that needed fast forwarding or anything like that. Because like I said, I didn't have time to edit it. Me? Never. All right, guys. Thank you so much for coming out tonight. Be safe, be well, sleep sweet, and much love.